and involves a violation of the pre-suit requirements, excuse me, under section 766.206. The requested relief is to dismiss the plaintiff's complaint, which we understand is an extreme request, and basically the plaintiffs are arguing no harm, no foul, because we proved our case at trial. But of course, any time that you have the issue of whether a complaint should have been dismissed, it's always after the fact, because you can't review that early on. So I would suggest respectfully that whether or not they did it at trial is not the issue, because the issue here is pre-suit compliance. There's absolutely no dispute that Dr. Klanke filed a pre-suit affidavit on standard of care and causation, putting 100% of the causation of Dr. Snyder's injury on Dr. Mishkel.
What about what about the affidavit of Jennifer Johnson?
Well, that's part of the no harm, no foul argument the plaintiff is making. Nurse Johnson testifies there was a deviation in standard of care by the nurses for failing to follow Dr. Mishkel's orders, which the affidavit of Dr. Klanke says were incorrect. So it's kind of a wash as far as we're concerned. I mean, all we have is these two affidavits pre-suit, and we need those in order to do the proper pre-suit evaluation, keeping with the spirit of the pre-suit statutes, which is for an early resolution of legitimate claims.
If we were to agree with you, though, wouldn't any time an expert changes their opinion then warrant a dismissal of a complaint?
No, I don't think this is just a question of an expert really changing their opinion. And they're arguing that under Cohen, they anticipate that there's going to be a change of opinion. There may be some change in various aspects of an opinion based on, as they point out in Cohen, later discovery, additional information. In this case, Klanke testified at trial. His opinion was exactly the same as it was in his pre-suit, which of course was not true, and we can't impeach him because we're not allowed to use that pre-suit affidavit at trial to impeach him. And he did not review anything new, additional, or different. He didn't testify, based on additional new discovery, I now have changed my opinion to X, Y, and Z. That is absolutely not what happened. We just had
we don't have that transcript, though, do we, in terms of the motion?
I'm sorry?
We don't have the transcript of the motion.
For the pre-suit?
Yes.
No. We have the pleadings, and we do have the argument that as long as the plaintiff does a reasonable investigation, a pre-suit affidavit cannot be the basis to dismiss the complaint.
Well, that gets them into court, though. I mean, and I mean, here at the time they filed it, certainly there's no indication that it was fraudulently filed at the time.
At the time they filed diametrically opposed affidavits, which at the very least should have put them on notice, because the defendant is left with affidavits that are awash. We have Mishkel being absolutely 100% liable for this incident with no involvement by the nurses, and Johnson, it's all the nurses and not Dr. Mishkel, because they didn't follow what Mishkel said, which Klanke says is completely wrong orders. So we are left with this situation. And so, respectfully, I think there was at least some indication that Klanke's affidavit was incorrect and should have been changed or modified before it was sent to us so that we can properly evaluate the case. The hospital has the right to decide whether to reject a claim, to make a settlement offer, or go to arbitration and admit liability. This case ended up with two opposing affidavits that essentially canceled each other out.
So had they only provided the Nurse Johnson's affidavit and not the other one, on standing alone, you would concede that'd be sufficient notice, correct?
It would be sufficient notice and a sufficient basis for us to actually properly evaluate the claim, because the claim would have been that only the nurses deviated from the standard of care based on Dr. Mishkel's orders. But we don't have that. We have the only expert who can testify on standard of care and causation saying everything that Dr. Mishkel did was 100% wrong. And so therefore...
Okay, you've confused me now. You have two affidavits pre-suit. One is by Dr. Klanke against Dr. Mishkel.
Correct.
Saying he was wrong.
Right.
And then you have a nurse
Right.
practitioner or nurse that testifies or has an affidavit saying the nurses were wrong.
For not following Dr. Mishkel's orders, which Klanke's has said, those are the wrong orders.
Okay. And you got both of those, or you didn't get?
Yes,
both?
no, we got both of them.
Both of those. Okay. And then Dr. Klanke,
Does 180
in his deposition,
and says,
the doctor-
everything Mishkel did is absolutely perfect and right and wonderful, and now I agree with Nurse Johnson, it's only the nurses who are at fault.
and did Klanke also testify at trial?
Yes, of course. And he testified to his changed opinion, which of course we can't impeach because we're not allowed to use his pre-suit affidavit.
Okay, can I just follow up? How far into the litigation did Dr. Klanke change, or was his deposition taken where he changed his
2
testimony?
years after his affidavit,
And
right before
at-
trial.
Well, and at that point though, you were aware, right? So you could have taken steps to do something at that point, no? To resolve the case if you felt that.
Well, we can't impeach him. We had our experts to disagree, but we certainly can't impeach him. But that's really not what we're talking about. We're not talking about discovery altering the trial later on. What we're talking about here is the requirements, which are not technical, for a reasonable investigation and compliance with pre-suit. And that really is the focus of the first 2 points on appeal. That the failure to do a proper pre-suit investigation by filing truthful affidavits has violated our right to be able to resolve this without going to trial, without litigation.
But you would have had your own experts that would have said, Klanke's off the wall here, because the doctor didn't do anything wrong. So how would that really prejudice you?
Because we don't get those experts until after this pre-suit evaluation is done. We're not even talking to experts at that time. The whole purpose of pre-suit is to avoid all of that, all that litigation, all that discovery, all that expense. That is the entire reason why we have such a complex pre-suit procedure.
Now, you characterize the affidavits as being sort of totally in conflict, but if you read the actual allegations that the nurse puts in there, the expert nurse, that Heather Walker failed to appreciate and recognize the anticoagulation of the individual, and she failed to apprise the doctor of the abnormal activated clotting. She failed to obtain new orders from the doctor. She failed to remove the sheath. I mean, these are things that, how would Mishkel know?
Because
that
Mishkel's
he
orders.
So that's, even if there are things in here about her conduct that have no contradiction to Mishkel's conduct, that you could find, that you say, oh, she should have called, she failed to get new orders from Mishkel. How is that contradictory?
Because Mishkel's, nothing that she did there would have conflicted with the orders that Mishkel should have given according to Dr. Klanke. He did not want, he wanted the sheath removed at 2 hours. He did not care about the clotting time. And those were the things that Klanke found were the causation of the injury. In other words, there's nothing there that's inconsistent with what Klanke was saying. These things are the things that should have been done.
I'm not saying there isn't a tension between the two. I'm just saying that there are conduct in here that, through this expert, which would apprise you of the nurse's independent failure to do what they should have done, like call the doctor because new things have happened. How could, so...
Well, the doctor, and then, I mean, at various times, and again, looking at all the facts, I mean, the hematoma appeared immediately after the catheterization. So the timing of who got called, when the hematoma, increased, etc. Those may have been acts of negligence, maybe did or did not amount to malpractice. Now, Nurse Johnson can't say those were the causation of his injury. She can only testify to standard of care. And again, we're looking at this in the time frame of pre-suit. And in the time frame of pre-suit, our position is that Klanke's false affidavit prevented us from doing a proper pre-suit.
So sue him.
Well, now that is an interesting thought, and perhaps you'd like to write that. in an opinion, because one of the plaintiff's arguments is the only person at fault here is Clanky, and therefore, you know, no harm, no foul again. But I'm not sure
If
that.
there's harm, there's your damages. Your damages are that he said one thing and caused you not to settle, and now you've had to pay X amount of dollars, and therefore you're damaged to that extent.
I suppose, I'm not sure that that determination wouldn't have had to be made by the trial court, who did not make it and would not make it, because when we asked to have the complaint dismissed, he didn't find any problem. He just said, well, if anyone should be sanctioned, it's Clanky, but he doesn't do that. And I'm not sure, you know, how our what kind of cause of action could go forward in light of the findings of the trial court.
So ultimately, though, the jury found that the nurse was negligent, and certainly there was testimony that the nurse noted some change in the condition that she should have communicated to the doctor. So that kind of takes the doctor out at this point, and the nurse is there by herself.
Well, respectfully, had we known from the get-go that it was only the nurse, and only the nurse had done something wrong, then maybe we could have settled this case or gone to arbitration and avoided all of this, including the appeal. The point is, we were deprived of that opportunity.
How can a plaintiff or a plaintiff's lawyer be responsible if a doctor is willing to attest to something under oath? If the doctor is willing to do that, how is that unless you're saying that the plaintiff's lawyer somehow went to this doctor and said, I'll give you 10% of my action here if you sign this affidavit so I can go forward on. I mean, unless you have some culpability on the part of the plaintiff or plaintiff's lawyer,
well,
how can they be responsible?
I understand what you're saying, and clearly we're not claiming any fraud on the part of the plaintiff's counsel. I think what happened here is that the plaintiff should have seen that they're submitting conflicting pre-suit affidavits to us that are awash. You know, if we read those and believed them, well, then nobody did anything wrong except Dr. Mishko. And, you know, how we deal with whether we should settle regarding Dr. Mishko's behavior as opposed to the hospital and the nurses, that's two different things.
As Judge Levine points out, there are other allegations in the affidavit as to the nurse's conduct other than just the time at which the sheath should have been removed.
I think that when we evaluated if it was just those other allegations, this would have been a completely different suit. But we don't know that, and see, that's the problem. And I realize the difficulty in looking at this issue, because we have to frame it in this very small amount of time of pre-suit, and not with trial. I'd like to leave my remaining time for point 2.
Okay. Thank you.
May it please the court. My name is Stephanie Serafin, and I represent the appellees, Dr. and Mrs. Snyder. With me today is trial counsel Chris Lamoya. This entire appeal is based on a view of the facts that is wholly unsupported by the record. As to the first and second issues, the hospital completely ignored Nurse Johnson's corroborating affidavit until the reply brief. The trial court found that there was absolutely no evidence that the plaintiff had failed to comply with any pre-suit requirements or evidence of fraud on anyone's part. As to the third issue, there's sufficient evidence in the record that Dr. Snyder continues to suffer from a baseball-sized mass in his groin that has modified his ability to work from a full-time position to a part-time position.
On the damages issue, as I understand the testimony, the doctor was making about $160,000 prior to this procedure working at the VA.
That's correct.
And then afterwards was only able to work kind of on a part-time basis, although tried to work, I guess, on a cruise ship that didn't work out well. And ultimately at the VA clinic, the outpatient clinic or somewhere, but he wasn't making nearly the amount of money that he made before.
That's correct. He never went back to the VA. He tried to go back to the VA, but they didn't have any part-time positions available. So he was working these locum tenens positions, trying to make some sort of a living.
Locum tenens doesn't mean part-time. That just means that you come in for a temporary duty, but you could be full-time locum tenens. Locum tenens usually are people, doctors go out on vacation or they're going away for a month. They need a doctor, they need coverage. You're still there full-time.
Locum tenens, in theory, could be a full-time year-round position. However, the evidence shows that Dr. Snyder was not able to work locum tenens positions year-round. He testified that he could only work part-time. His wife testified that his injury made him only be able to work part-time, and Dr. Kowalski testified that he had a permanent condition.
Well, Counsel, isn't one of the problems, though, that the only testimony about his lack of ability to work full-time was from the doctor himself, and he wasn't testifying as an expert at that time, he was testifying as plaintiff.
That's not a problem. According to the decisions, several decisions, the Cox versus Shelley decision from the 3rd District, there was only evidence. The plaintiff testified he was a journeyman, and he needed the help of journeymen to complete his work, and that was sufficient to send the issue to the jury of lost earning capacity.
How much money was actually, didn't you request, or not you personally, but plaintiff's counsel requested significantly more than you ultimately got?
Yes, well, plaintiffs, Dr. Pettengill testified to a range between 5 years and 7 years of future lost earning capacity. The jury awarded $280,000, which was less than that range. It was about maybe a year and a half of lost earning capacity.
Is there one job on the record that he turned down because it was not part-time? I mean, because I thought that he turned down the cruise ship, or left the cruise ship because of the accommodations. He left one of these other doctors because the general practice, because he didn't think that they were scrupulous and all that. He, was looking. Wears locum tenens, but that, as we've already established, can be full time, as you've admitted. So, is there any job that he was either a part time or turned down a full time in order to be part time? Because even VA clinic, that's a full time job.
There is evidence that, in fact, his contract with the VA clinic was terminated after his injury because he called them and told them, I can't work full-time anymore. I can only work part-time. Do you have anything? And they said no, and he kept calling back. He called his Medmark, which is the contractor, and he called the VA, the Human Resources Vice President, and said, do you have anything part-time? And they kept telling him no. So he went on to try, and he had to do something to make some money, so he went to these locum tenens positions.
Let's talk about the pre-suit notice.
Okay.
Is it your position that you can have pre-suit notices that are contradictory on its face?
Yes, and because the question is not whether later evidence makes a pre-suit expert change his opinion. The question is whether the pre-suit notice and the pre-suit affidavit is reasonable at the time it's given. And as the Supreme Court recognized in Cohen, that's at a time when almost none of the relevant discovery has been done. It's based on essentially the medical records.
What would be the remedy in a situation like this where potentially one defendant is unable to make a reasonable settlement of a dispute based on an affidavit that turns out to be totally contradicted by that expert in the subsequent litigation?
I don't think that the pre-suit requirements require that, in fact they don't. The Davis decision says that the plaintiff doesn't have to give an elaborate theory of his case at pre-suit so that whoever can decide whether to settle. The question is just whether the decision, the affidavit is reasonable at the time it's given. So it's not a question of what the remedy is. The remedy, once the discovery comes out, the defendant was well aware of what Dr. Klenke's opinion was and had the opportunity to go to trial and flesh out that opinion and have their own experts. But the question of what remedy is necessary, I don't think there's any remedy necessary.
Did it matter that there were other allegations in the nurse's affidavit that could have been different than the dispute between whether the doctor or the hospital were negligent just for that 2-hour period of time where they removed the sheath? In other words, Judge Levine has pointed out that the nurse's affidavit has other allegations against the nurses in the hospital other than just removing the sheath at that 2-hour point in time. Had they been exactly the same and diametrically opposed, would that put you in any different position?
If I understand your question, I think Judge Levine's point was a good one, and it brings up the issue that there can be several deviations from the standard of care. It doesn't have to be that only the nurses were negligent or only the doctors were negligent, and all of these can contribute to the plaintiff's ultimate injury. And in this case, Nurse Johnson's affidavit matches what was testified to at trial, that the nurses failed to appreciate the level of anticoagulation and failed to call Dr. Mischel and say, hey, we didn't follow your orders. What should we do now? His ACT is 211. It's not a safe range.
So, Counsel, one of the issues, though, is questions is if you have multiple defendants, though, and if one affidavit actually exonerates the other defendant and inculpates one defendant, and you have both affidavits or two affidavits in these multiple defendants where one exculpates one of the potential defendants, and at the same time the other affidavit exculpates or inculpates the other, and you've got these cross motions, and possibly that was going on in this case.
No, that wasn't actually what was going on, because Dr. Clanky didn't give any opinion about the nursing negligence, because that wasn't his job. His job was to
Well, yeah, but I mean, his expert's testimony was that the sheath should have been removed precisely 2 hours after a certain event, and the opposite view from the nurses was that they waited too long, or they didn't do it at that particular time.
Well, because, and just to go into a little bit of the medical testimony here, the issue isn't whether it's too early or too late. The question is that Dr. Snyder had several anticoagulant medicines in his system, and there were certain windows at which it would be safe to pull the sheath. One of them, as it was discovered at trial, was the 2-hour window that Dr. Mishkel ordered. After that 2-hour window was blown because the nurses completely ignored his orders, then the question was, what's the next safe window? Well, the nurses never called to say, can we pull the sheath now? They just did it on their own. And so that was the nursing negligence, and that's what Jennifer Johnson, that's the same opinion she gave in her affidavit and the same opinion that was given at trial. If this court has no further questions, we ask that you affirm the final judgment in all respects. Thank you.
Thank you.
As quickly as I can in 2 minutes. Dr. Pettingill, the plaintiff's economic expert, testified the plaintiff had no future diminished earning capacity because he could work as a doctor, and that it was very easy for him to find a job as a doctor. This is not a situation where the doctor needed help to diagnose and treat patients. Dr. Pollack, Dr. Snyder, and Mrs. Snyder all testified he could work completely fine as a physician. He could work full-time because he took 2 full-time jobs and left them early for reasons completely unrelated to his condition.
Doesn't that still leave it to the jury to determine what is earning capacity?
Respectfully, no, and this is why the judge kept coming back to this 3 times on this issue. He kept asking the plaintiff, where's the evidence of diminished earning capacity and how the jury can calculate it? And the plaintiff's answer every time is what you heard today. He's making less now than he made before, and we've given you the litany of cases that say that is not what you do for diminished earning capacity. You have to find that something about being a doctor is missing due to the incident that doesn't exist post-incident. There's something that affected doing that particular job. As the court pointed out in Cardosa, the guy was a flower vendor. He could be a flower vendor after the accident. He chose not to do that. This doctor wanted to work full-time at Delray VA. His job had been filled because of this incident. That's the only reason he couldn't go back to working full-time at Delray. They said there are other full-time VA jobs available. Check the website. He never did that.
What's your best case in that issue?
I think that well, W.R. Grace probably, and everybody that cites that you need to have a basis to calculate diminished earning capacity, and it's not what you made before and what you made after. Because if that was true, everybody who made more money after an incident could never have an award of diminished earning capacity, and that simply isn't the case. Regarding the conflicting evidence now we're hearing today, it wasn't a too early or too late in the removal of the sheath. That's the main focus of those affidavits. Too early, too late. Complete in conflict. We had no way to properly evaluate this under the pre-suit requirements, and reversal is required, and we think dismissal of the complaint is warranted, and at the very least, a reversal of the diminished earning capacity award.
Thank you very much. We appreciate your time today.